Hey guys, how's it going? Okay, Mark O'Mara has said that he's not going to have enough time to prepare for his trial. There's just no way he's going to have enough time. So he's not going to waste even a minute with a stand your ground hearing with the judge, because basically that's what the jury's going to do, is have a stand your ground hearing. That's what this trial is. It's a stand your ground hearing with the jury. Now, George is entitled to 2 stand your ground hearings. The first one would be with the judge. Apparently, they don't believe that this judge is unbiased, and they don't feel that it's going to be they're going to have an opportunity to remove her from her position. And as much as I agree that she appears to be a little biased, I would say it would still be an excellent idea to run this through a stand your ground hearing, because it gives you an opportunity as a defense team to prepare. Having a mock trial with a real group of people there. You've got the prosecution with all their evidence just laid out before you. What possibly could be a better preparation? Anyhow, let's take a little listen.
Are you ready for trials? That's what we're doing. Don't know if there are any questions, but
Are you going to
that's
have
our plan.
Are you going to have a simultaneous immunity hearing during the trial?
Haven't made that decision yet. The real focus is going to be on getting ready for a jury trial.
So he's leaving the door open. He didn't say whether he's going to have a stand your ground hearing or not. Hadn't made a decision on that, whether it's going to roll it in. My personal opinion, and this is what I would do if the judge had jammed this date on me, is I would call for the stand your ground hearing the day before their trial date. The truth is, he can't be denied the stand your ground hearing, and he can ask for it at any time right up to trial date. The court's schedule is not an indicator on whether he can exercise his right, and at no time did he say that he was giving up that right in the hearing. In fact, the judge verified that again at one point in the hearing, that he at no point did they give up any rights to a stand your ground hearing.
As you know, I've been counting. We're at 96 days right now, so that only gives us time to really get ready for one hearing, and that's going to be a jury trial where he gets acquitted. So that's my plan.
So could there be a possible...
So there you've heard it. His plan, at least what he's telling people right now, is that they're going to have the hearing, the stand your ground hearing, with the jury. That's the plan. So the jury's going to hear that case. And as everybody knows, because some people, I saw one video where the guy apparently doesn't even realize that by not having the stand your ground hearing, this guy's video said that he's almost admitting guilt. I don't think so. He's just admitting that the court is going to be biased, and that he's better off just going straight to the jury rather than waste his time. And as I've said, I disagree. Running a stand your ground hearing first will give the defense all kinds of benefits, and there is no negatives. So if you have 96 days, well, you've got 95 days to prepare for the stand your ground hearing. I mean, if they're going to force you to have a trial in 96 days, well, then on the 95th day, just say, I'm ready for my stand your ground hearing.
Plan for a civil immunity action after the trial and just make the trial the focus?
The trial is the focus. We're looking forward to getting an acquittal at trial, and that's...
So that's what he's saying. That's the point. And if that's really what they want to do, is just completely avoid the stand your ground hearing with the judge, that I think is a mistake, and I would consider that to be a grounds for overturning a conviction. Of course, O'Mara could just simply state that he was forced by the judge to run into a trial before they could possibly be prepared. And the judge has said that they should have been prepared, that they should have already deposed all these witnesses. They've had all this time, but the truth is Dee Dee hasn't been available to be deposed. For the longest time, she was told she was considered to be a minor and that she was out of reach of the defense. And now we know that she lied. So, I had already said that, and my first videos on this whole case was on Dee Dee, and I pointed out at the time about her lie on the hospital visit and the fact that I thought it was a stupid lie because it was worthless. It was not a helpful thing. They didn't need to even say it. They brought it up, and then they lied about it. Why didn't she go to the hospital, or why didn't she go to the wake to see him and his body? Why? Why? Because she went to the hospital. No, she could have just said, well, she just wasn't feeling good that day, or, it just made her feel bad. Whatever. But when you lie and use a lie that can be verified, it's, doesn't make a lot of sense. It shows that certain people that are involved in this case aren't all that bright.
Really what counts. If we're going all the way through a jury trial, I look forward to a jury verdict. So that's my plan.
Sorry,
What
missed that.
about
You
witness
saying
number
immunity
8?
Hearing after the trial. What were you saying there? I missed that.
I think Bob said, could there be a possibility of a civil immunity or something like that afterwards?
But what are your options here when it comes to an immunity hearing? Now that you've said you're not doing April, she's cleared her calendar, now she's filling it up. Her calendar's going to be full before June.
Seemed to be.
So what are your options?
Well, we could either decide to wrap it into the trial. We can decide not.
See, he said, what about the stand your ground hearing? How are you going to have it if you've got this deadline? And he said, are you going to wrap it in, or, he said, well, it seems to be that's the deadline. Seems to be. And he hasn't decided whether he's going to wrap it in. Let's listen to that again.
Seemed to be.
So what are your options?
Well, we could either decide to wrap it into the trial. We can decide not to. Certainly, one main focus that we have is to get him to a jury and get acquitted. A second focus is then to maintain his civil immunity whenever that becomes relevant. And we'll see about that as the time comes up.
And that's an interesting point that he brings that up, and it makes me wonder, what's possibly. I'm assuming this is not the first time he's had a stand your ground hearing, but the immunity is automatic as soon as he is acquitted of, if he's found to have been in fear for his life at the time he shot Trayvon Martin, then he gets immunity. That's how you don't get arrested. You either get immunity or you don't get immunity. If he has immunity and he is found to be innocent because of that or not guilty, then there is no opportunity for civil liability under the stand your ground law. Florida Statute 776 is really clear on this matter. I know that George's brother was on TV and talked about it, and he clearly doesn't understand stand your ground, and it was obvious that he didn't get it, and that's why I'm concerned that maybe George is missing out on his opportunity, and it makes me concerned about O'Mara. How could a lawyer miss such an opportunity? It doesn't make any sense to me. It's got to be either a trick that they're pulling, or they just absolutely know that this judge is not going to listen favorably to the evidence. But if I were George, I would wait until the very day of the trial, and then I would request my stand your ground hearing, and I would bring out every piece of evidence and make a complete mini trial with all the evidence on both sides. I would make the defense or the prosecution bring out all their evidence, and I would force the hand of the judge. This is a very high stake case, and if the judge were to rule wrongly on this case because of her prejudice, it wouldn't shine brightly on her being in elected office and all. You want to make sure that the people are happy with you. And right now, George is more popular than he was, quite a bit more popular. Everybody that used to think that George was guilty, now many people have been swayed because the facts came out piecemeal. But I tell you, I got to wonder if George made a mistake by switching lawyers. The first ones were like little pit bulls. You know, they were on the case. They had all the information and the facts. And O'Mara here, he's just like, he's telling us, he's just a little wishy-washy. It's hard to know what's in his mind. But all I can say is if George gets the opportunity, he definitely should go through the stand your ground hearing first, regardless of what the judge says or does, because that's going to force her, put her on the spot, and it doesn't cost you anything extra. It's just biding time. It gets to slow down the process. It also gives you the opportunity to see all the little hidden secrets that they're planning on throwing out, little things that they've hidden in the background that are going to all come out at the last minute. Well, if you have a stand your ground hearing, then it won't come out at the last minute. You'll get it all up front. Don't let this golden opportunity pass you by. This is why the Floridians put this law in place, so that you don't have to go through all this crap. And the judge had better hear it, and the judge better find properly. I also have a problem with O'Mara taking 96 more days. It doesn't make any sense to me. We've got all this evidence stacked up. I mean, do we need to make all these witnesses look bad? Do we need to make Dee Dee look like a liar? I mean, yes, she's a liar. We know it. I think we've got more than enough evidence of that just with her deposition. And now they're pointing out the fact that she lied under oath. That's wonderful, great, that's good. Now we know. So let's move on with this. Let's just go ahead and have the stand your ground hearing. We could have it tomorrow. It's not going to cost you anything, just a couple of days. I mean, it's crazy not to do it. And to give up those days that she's already set aside and say you're not going to have it at all, that doesn't make any sense. But I heard the judge say that the fact that you gave up those days doesn't mean that you can't have the hearing. You still can have it, call it right up to the last minute. And that better be what the plan is. You can't really roll it in because the stand your ground hearing with the judge is totally separate from the jury trial or the jury's stand your ground, because the jury doesn't get to hear what happens in the first hearing. That's the whole point of it. That's why it's such a good deal, because you get to see all the evidence. You get to find out all the facts, and then you get a second shot at it. Clean slate. I personally can't imagine the judge not granting it, and maybe that's their concern, that the judge would grant it, and then the people wouldn't accept it, and George would have to go into hiding. And that sounded like one of the issues that he had.
What about
Really,
witness?
those are the alternatives, and that's our plan.
What about witness number 8 lying under oath? Witness number 8.
Let me
When
go
will
ahead.
you make a decision about rolling the immunity into the trial? When does that need to be made by?
I don't think that there is a deadline when it needs to be made. I think that the judge might expect a motion to be filed. But, my plan right now is to just move forward getting ready for trial.
So there he said it. There is no deadline for when you can file your stand your ground motion. And it's not something that she can deny. I mean, she can't just say, no, you can't have a stand your ground hearing. She can't do that. She doesn't have that power. So anyway, I just wanted to bring all this stuff up. I didn't expect it to get this long. So good